Okay, well, good evening, everyone. The end of a very long, hot and sunny day. Hopefully everyone's been keeping hydrated. We are joined this evening for our second seminar today, the latest in Conor's QS series. Tonight he's going to be discussing or dealing with adjudication from a QS point of view. As always, if you have any questions, Conor is more than happy to answer them. But if you can pop them on the QA question facility in the bottom toolbar, we will get to these at the end, and Conor will answer as many as possible. So without any further ado, Mr. Ahern, I'm going to hand over to you. So Conor, the floor is yours.
Okay, thank you very much, Julie. Good evening, everyone. I hope you're all well on this lovely sunny evening. Tonight we're going to be looking at the latest in what I call the QS series, and we're going to look at adjudication. And there's a couple of points here that I want to clarify with you and just help you to gain a better understanding of them. And we'll get stuck into that now and hopefully, and yeah, we'll get going on that now. Sorry, my notes have been moved there. Okay, so yeah, look, that's a bit of me. That's my background. So yeah, previously a quantity surveyor, hence why I call it the QS series. Yeah, there's some information there for me if you want to read it. All of this information is on our website as well. So feel free to to download the slides there as well once this is all over. Okay, so just some housekeeping, as Julie said there. So there's so if you have any questions, please put them into the questions and answers box. I'll answer these at the end, just because it's easier just to keep going through the materials rather than getting bogged down in some questions in between. I actually already have one question in this evening, and that was in relation to, can parties agree to exclude adjudication in their contracts? So look, that gives you some food for thought as to what typically gets asked in the Q&A. So get thinking, and please send in your questions. Also, just to bear in mind that this is not legal advice. It's for education, just trying to help you guys gain a better understanding of the issues that we're going to talk through. Okay, so it's just a bit of an agenda. So look, tonight we're going to look at smash and grab adjudication briefly, because that paves the way nicely for what we call true value adjudications. And I'll explain to you the current position there following the case of Grow versus S&T, which is a very popular case, very important case, and we'll go through the reasons why it is shortly. We'll also look at insolvency and adjudication. Now, this is one that is hot off the press because the Supreme Court released a judgment last week, which basically changed the position on that. It's very important. It was a case of Bresco versus Lonsdale. And you've probably read a bit about this, on LinkedIn or, on various, through various websites. But again, we'll go through that in a bit of detail, give you some background, and hopefully develop the understanding. And finally, we're going to look at COVID-19 and adjudication. Look, obviously, we've all been impacted by COVID-19. And this was a case that came up about 2 months ago. It was the case of Milchrist versus Waters. And it's helpful in respect of, what's seen as an excuse to, delay an adjudication now as a result of, what was the lockdown, obviously, which we're now coming out of. But it's a good insight into, what the courts say the parties must do when they're dealing with such circumstances. Okay, so yeah, just to finish off the introduction. So there's been some other webinars in this series. So we did the interaction between construction law and quantity surveying. We dealt with variations, loss and expense, and payment. Now, as I said here, the aim of these seminars is or this series is to assist quantity surveyors and indeed other members of the project team. I'm not trying to discriminate or show favoritism to quantity surveyors in any way. But look, I just want you all to understand, how to manage these topics when they occur, and just to have a better understanding, so as you know how to deal with them better during your respective projects. All these webinars are actually available on our YouTube channel, and there's a link there. But if you go to YouTube and just put in Silver Shamings Ashdale, I'll pop up for you as well, okay? Right, so to start us off tonight, we're going to have a bit of an introduction into what is a smash and grab claim. Look, smash and grab is a term synonymous with adjudication. Not always not always seen as a positive thing that came out of adjudication, but it's here and we have to deal with it. And so just a bit of background into what is a smash and grab claim. So in essence, a smash and grab claim is made by a contractor who acts on an employer's failure to issue a valid pay less notice by claiming payment of sums stated in the interim application for payment, with no regard to the employer's assessment of the validity of such claims. Where a project has regular interim payments built into the risk is somewhat lessened by the employer's ability to undo the effects of an unjust claim in the next interim payment. Now notice the emphasis there on interim payments, because obviously if you have 10 payments in a contract and basically the employer fails to issue a pay less notice at payment 5, well then the employer can rectify any what they feel is maybe sums overpaid in the subsequent interim payments. But then for this reason, contractors have become more likely to pursue this style of claim in respect of the final interim payment or the final account payment, where the employer's opportunity to undo the claim via the final account process may take some time. Now, so that leads us into the case of Grove Developments versus S&T. Now, this was in the TCC 2 years ago. I started my training contract 2 years ago, so this case is one that comes up pretty much daily. I mean, obviously it deals with true value adjudications, but also very important in respect of the current position on pay less notices as well. So just some background here is that Grove contracted with S&T to design and build a hotel at Heathrow Terminal 4. Now, S&T commenced the works in March 2015. There had been multiple adjudications between the parties. Interestingly, S&T were the referring party in those 3 adjudications. Now, in the final adjudication, Grove had anticipated an adverse result, and they actually commenced CPR Part 8 proceedings at that time. Now, the reasons why this is a significant judgment is a ruling that the employer was able to challenge the amount due to the contractor as a result of a smash and grab, even if there was no valid payment and/or pay less notice. In his judgment, Coulson expressed his dissatisfaction with these types of claims being smash and grab type claims. He said, "I believe that my conclusions will strengthen the system because it will reduce the number of smash and grab claims, which in my view have brought adjudication into a certain amount of disrepute." Now, so the legal issues here, just clarify, so you've got A and B, that was in relation to the validity of a pay less notice. We actually discussed that in a lot of detail in the payments webinar probably about a month ago. So if you have any queries on that, then do check out the payment webinar on the channel. Issue C, now this is the one we're focusing on tonight, and the question here was, could Grove commence a separate adjudication in order to determine the true value, which we'll deal with now. And the final issue there was, were Grove's liquidated damages notices properly issued, which is an issue for another day. So the one we're going to focus on here is issue C, and could Grove commence a separate adjudication to determine the true value? Okay, so again, Coulson is saying, my conclusions reached on this issue will be of most interest to the construction industry and represent a change of approach from the previous authorities. Coulson was clear that an employer can commence a second adjudication to seek the true value of the sum due, whether it has failed to serve an effective payment notice and/or a pay less notice to the contractor's application. And in doing so, he gives 6 reasons for his decision as to why the second adjudication could be commenced. Okay, so going through those 6 reasons, so the first one was that Coulson said, the early case authority of Henry Boot Construction versus Alstom Combined Cycles noted that it had always been open to the court to revise architect certificates, and this was authority for the court's ability to consider the true value of an interim payment application. Now, so what he's saying there, and he's basically saying that the court has the power to do that, and he's saying that the adjudicators have the same power. So that's point 1. then he moves on to say that there was no limitation on the nature, scope, and extent of the dispute, which either side can refer to an adjudicator. And as such, there is no limit or restriction on the power of an adjudicator to decide this issue. So he's saying there's no limitation here. And the courts are very slow to limit or restrict the powers of an adjudicator. So he's saying we're not going to look at it here. The next point was the second adjudication to consider the true value would be a different dispute to the validity of a pay less notice as decided in the first adjudication, as it would address questions of valuation. So what he's saying is that there's no problem with jurisdiction, as the original adjudication only dealt with the point as to whether the pay less notice was valid. So therefore, the second adjudication was to actually determine the amount that was due, which is a completely separate dispute. And what he's saying is, therefore, there is no issue with jurisdiction, and the adjudicator for the second adjudication has jurisdiction to consider such a matter. Point 4 then was that the JCT distinguishes between the sum stated as due, which is the amount in the application for payment, and the sum due, which is the correct payment amount, in brackets, the true value. So long as the sum stated as due has been paid, the sum due can be adjudicated. Now, that is probably the most important point to remember here, is that it is a condition of starting that second adjudication, is that the sum stated as due from the first adjudication has to be paid in order to start that second adjudication. Very important point. Now, I mean, if there's issues in relation to, the financial standing of the, of the payee, then you've got to look at that on the facts and based on what security may be required. But what the courts are saying is that the sum stated as due has to be paid. Point 5 then is saying that as a matter of equality and fairness, the employer's ability to adjudicate the true value of the application must be balanced with the contractor's ability to do likewise. It would be wrong to prohibit the employer from doing that which the contractor can do. So he's saying it's in the interest of fairness that the employer has to be able to assess the true value in the same way that the contractor can. So like it's an important point to make, because he's saying that it works both ways. So that's what he's referring to in point 5. And point 6 then, and the final point, is that there is no justification for the previous authorities that distinguish the employer's ability to adjudicate where there is a final application as opposed to an interim application. There is no such distinction in the JCT form, and there is no difference between payment rights and obligations in respect of interim payments and the final payment. So what he's saying there is that, if the smash and grab adjudication was on and the earlier interim payment, then in the subsequent interim payment, that would be corrected. And what Coulson is saying is that he doesn't see any reason why that same principle does not apply when we're dealing with a final payment. Okay, so we're saying that the judgment represents a significant change in the TCC's approach. Coulson has endeavoured to bring clarity to the influx of potential issues raised by earlier cases on smash and grab style adjudications and distinctions between interim and final account applications. The comments of the judge have the potential to reduce the impact of contractors' claims for payment on the basis of failure to serve a pay less or payment notice, now that there is authority in support of the employer's ability to quickly bring a second adjudication for the true value on the same application. So that, that's the key point, is that the authority is that he can quickly bring the second adjudication, but on the proviso that the sum stated as due is paid. And that is the key point to take away from Grove versus SNT in relation to this true value adjudication position. And the key point is that the sum stated as due has to be paid, and then you can re-adjudicate on the sum due. Now, the reason, it's a very important case, as I was saying, that 2 years ago, and I've dealt with it, a lot. I mean, it's probably the most popular case that we deal with in adjudications, but that is probably the most common misunderstanding, is that parties always ask, can I avoid paying the sum, the amount awarded in the first adjudication before we re-adjudicate, and the authorities are clear that you cannot do that. You have to pay those amounts and then re-adjudicate. You obviously have the, if you obviously have the option of commencing litigation proceedings or arbitration if there is an arbitration clause in your contract, but that's not taken, those options are not taken up that very often because of the the time involved in reversing the decision. So that's why the second adjudication is so important. And there's been a case recently that has basically just reinforced that position in Grove versus S&T. It was a case of Broseley London versus Prime Asset Management Limited. It was a TCC case back in February. And the question here was, can an employer start the true value adjudication without first paying the notified sum? Again, like I said, when discussing Grove versus S&T, what he said was the court confirmed that to allow this would be a remarkable intrusion into the principle established in Grove versus S&T, and the party could not commence a true value adjudication without having paid the notified sum. This would permit the adjudication system to trump the prompt payment regime, which should not be allowed to happen. If it was open to commence litigation proceedings if it wished. So there, the TCC are reinforcing the well-known principle that came out of Grove versus S&T, which actually the Court of Appeal agreed with the findings in Grove versus S&T as well. So a very well-established principle at this moment in time. What I guess just some personal experience is that what it does is, what the courts are doing is that they're basically saying is that, don't think that you can get the smash and grab on the final account because you can go back, for the true value, which is a big change of position because previously the previous position was a smash and grab on a final payment was valid, and you had to go through alternative proceedings then in order to cover any amounts that were, incorrectly paid. So it's an important change. It's good for the industry. I think what it does is that it's been used, and I've seen it being used as a good tool to get parties to a table to negotiate. Because rather than want to go back through the second adjudication, sometimes it works, the negotiation. Other times, we do see quite a significant amount of the true value adjudications as well. But that is a position. So if it does happen and you want to go for it on the final account payment, just bear this position in mind, and obviously have it in the back of your head that to start that second adjudication, you have to pay the amount required under the first. Okay, so that wraps up the position on true value adjudications. So we're going to move into the area of insolvency and adjudication. Now, this came out of the Supreme Court. It was only last week. It was last Wednesday, I believe. It was the case of Bresco Electrical versus Michael J. Lonsdale Electrical. It came out of the Court of Appeal. And just to give you some background, the legal background, I guess, is there was some debate as to, there were in the relationship between an adjudication regime for building disputes and B, a rule of insolvency law called insolvency set-off. Now, what was said was that both systems were incompatible, and the reason why they were incompatible is that adjudication, when it was introduced, the principle that's been well enshrined in many an adjudication decision is the saying that pay now, argue later. So and then insolvency set-off, that is a point, deals with the liquidator calculating net amounts due after setting off other amounts. So insolvency set-off is focused on getting to the right number rather than what adjudication is, pay now, argue later, regardless of the of the merits of that number. So what was said in the Court of Appeal was that there was an incompatibility, and it's a very important point, and it has now been dealt with. So just to give you some background into this case is that Bresco and Lonsdale, they were both electrical contractors. In 2014, Lonsdale engaged Bresco as a subcontractor. The project was in St. James's Place here in London. Now, in 2016, Bresco entered into insolvent liquidation. The position at the time was that both parties had debts against each other. Lonsdale had alleged that Bresco owed them $325,000 for prematurely leaving site, and Bresco alleged that they were owed monies totaling $219,000 by Lonsdale in relation to unpaid works plus damages. So then the liquidator picks up the file for Bresco, and then they make the decision that they're going to pursue the $219,000 through an adjudication, and this what sets the ball rolling. Now Lonsdale objected on two grounds. The first ground was jurisdiction. So Lonsdale was saying that the set-off point meant that there was no dispute. And therefore the adjudicator did not have jurisdiction in order to in order for the adjudication to commence. Now, what they meant by that is Bresco. Bresco saying that they were owed $219,000. Lonsdale saying they were owed $325,000. Lonsdale are saying basically that the Bresco claim is distinguished, so there can be no dispute because the amount that Lonsdale was looking for was greater than the amount that Bresco was looking for. So that's what he's saying, is there's no dispute, as there was there's no difference between the parties. And then the second ground here was that it was a futile exercise in any event, because the adjudicator calculates the net balance, so adjudication was pointless. So that brings us, that's on the incompatibility point. So that's the reason why Lonsdale objected to the adjudication on both those grounds. Now, this case, so it started in the TCC, and the TCC accepted both of Lonsdale's points and granted an injunction to stop the adjudication. So what happened then was Bresco appealed, and the Court of Appeal rejected Lonsdale's jurisdiction point, but upheld the exercise of futility. So the injunction point remained in place. Now then the Supreme Court considered that Bresco's appeal on both grounds and Lonsdale's cross appeal on the jurisdiction point. And so this is what it decided. So on 17th of June 2020, the Supreme Court unanimously allowed Bresco's appeal and dismissed Lonsdale's cross appeal, meaning the adjudication can proceed for the following reasons. So the first was the jurisdiction point. And what the Supreme Court said was that the claims do not automatically melt away simply because one of the parties is in liquidation. Rather, they say that they retain their separate identity. Despite insolvency set-off, Bresco could still bring court proceedings to determine the claim value or pursue arbitration. It follows that it could also refer this dispute to adjudication, because they're saying that the claim still exists, and because Bresco could, if they wanted, they could issue court proceedings, they could pursue arbitration, and similarly, what the court is saying, that it should still be allowed to adjudicate as well. It should still have that option available to it. So what he's saying is that there's no issue with the jurisdiction, and adjudicators, will satisfy that they will have jurisdiction to decide such matters. So then we move on to the futility point. Now, the Supreme Court rejected the incompatibility between adjudication and insolvency set-off as upheld by the Court of Appeal. Now, Bresco has a statutory and contractual right to adjudication, and it is inappropriate for the court to interfere with the exercise of that statutory and contractual right. Maintaining cash flow is not the only purpose of adjudication under the 1996 Act. Adjudication was designed to be a method of alternative dispute resolution in its own right. In reality, most decisions of an adjudicator are never challenged in court, and they lead to a speedy, cost-effective, and final resolution of the dispute. So here you can see, the Court of Appeal is, saying how successful adjudication is and how successful it has been, which is an important point, because it's, you know, it's recognizing that, you know, most, like, whilst it may not be perfect, in reality, it's saying most decisions are not challenged. And what he's saying here is that even if the adjudicator's decision is challenged, that can still be decided on the merits as well. So, you know, kind of, you know, the Supreme Court giving adjudication, supporting adjudication, and re-emphasizing the importance of adjudication in construction disputes. And the final point here is that here an adjudication will be a simple, proportionate method for Bresco's liquidators to determine the net balance. It is possible that the courts will not grant summary enforcement of the adjudicator's decision due to the insolvency process, but that does not deprive the adjudication of its potential usefulness to the liquidators. So what it's saying is that, you know, adjudication is proportionate, and liquidators should have access to consider the point. Now, in relation to the enforcement, you know, the courts may not grant summary enforcement of the decision due to the insolvency process. That will all turn on whatever the facts are in each particular case. But the main point here is that you know, they're not going to deprive the adjudication and its usefulness to liquidators. So again, he's saying that liquidators absolutely can bring, you know, can choose to recover any debts through, you know, through adjudication. So, like, the position has been unclear for some time. So now it's been clarified through this judgment. So in conclusion, liquidators and administrators can resolve an insolvent company's claims through adjudication. And now this is helpful as well, especially considering, you know, the current economic outlook post COVID-19. And what is expected, you know, unfortunately, you know, some companies won't make it, and may well, and it is likely that there will be an increase in insolvencies. So, you know, the industry is expecting that liquidators will choose adjudication to try and recover any sums that they believe to be due to the insolvent party. It reinforces the court's position that adjudication works, and only in very limited circumstances will they prevent a party from using it. So again, you can see, you know, the courts are really supporting adjudication here. They believe in adjudication. They believe it is, you know, it has been a big help to construction, and it has helped to, you know, alleviate a lot of the problems that existed in the industry pre-adjudication. So again, it's, you know, the adjudication is getting the seal of approval, from the courts. And what they're saying is that it's only going to be in very limited circumstances that they're actually going to prevent a party from using it. So yeah, that's the outcome from that. So, you know, do expect that, you know, liquidators, administrators will be more active in the adjudication arena moving forward. As I said, this case was only released last week, so, you know, we wait and see, you know, what the real impact of this is on the ground. Okay, so now we're moving on to COVID-19 and adjudication. So this is obviously a very timely decision. It was released, about 6 or 8 weeks ago. It was a case of Millcrest Developments versus Waters, and yeah, so the legal background here was, the question was, you know, could a party be granted an injunction in an ongoing adjudication because of a belief that circumstances related to COVID-19 would result in a breach of natural justice? So the party was saying, you know, we believe an injunction should be provided, you know, given restrictions in relation to, you know, the lockdown and other, you know, logistical points, you know, that obviously got, you know, that became a lot more difficult during, you know, since the impact of COVID in mid-March. So, you know, on that basis, could it be sufficient so as to deny a party its right to, you know, to have their case properly heard, and or would this potentially be a ground as a breach of natural justice? So, so some case background here was that Waters was a homeowner and Milchrist was a contractor / developer, mainly a developer. So in September 2017, Milchrist carried out works at Waters' property. Now then in November 2019, Milchrist, they ceased trading, so they alleged. Now in March 2020, Waters alleged overpayment of $45,000 and commenced an adjudication against Milchrist in order to recover, those alleged overpayments. So the adjudicator was appointed and requested evidence to be submitted to him by the 3rd of April 2020. The adjudicator also requested a site visit on the 14th of April. Given the fact that there was alleged overpayments, so he wanted to ascertain, whether the works had been carried out or not, and if those works were carried out, were they carried out in accordance with the contract. Now, Milchrist asked to postpone the adjudication due to COVID-19, and so the adjudicator proposed it. Then the adjudicator responded and proposed a 2-week extension to the timetable to deal with the additional time required to deal with COVID-19. So you can see the adjudicator is alive to the fact that there will be delays, and he sees the most appropriate method of dealing with those is by granting an extension of 2 weeks. Now, so what happened was Milchrist did not agree to the extension, and as such, they sought the injunction. So here we see Milchrist applied for an injunction to prevent the adjudication from continuing and arguing that this was a breach of natural justice on one point, as they had ceased trading. They needed time to obtain evidence from witnesses and people who had been involved in the project. So they're saying that that was going to become more difficult as a result of COVID-19 and social distancing. Milchrist's solicitor was actually self-isolating at the time, and that's what they said to the court, and that was due to COVID-19 as well. So, you can see that. And finally, it did not have time to instruct an alternative solicitor to attend the site inspection, as well as they were pretty adamant that they wanted to have somebody present at the time of the inspection, which was on the 14th of April. Now, the reason why natural justice is so important, I mean, it's very important in enforcement because, it's key, and because it's one of the few grounds available in order to resist enforcement. So it's something that's taken very seriously by the courts. And obviously, if it is going to fall down there, then is there any merit to continuing the adjudication? So the TCC they released their judgment, and they refused to grant Milchrist the injunction, and it did so on the basis that they said that the contractor could have scanned documents either to their solicitor or another solicitor, who was actually self-isolating, or they could have appointed an alternative solicitor. So they didn't see that as serious enough to grant an injunction. They also said that there was no need to be present at the site visit, as they could have provided a list of matters to the adjudicator in advance of the site visit. So they're saying that there was no need for them to be present. You can submit your list, and the adjudicator will take that into consideration when he attends site, and that's absolutely right. He's saying that the contractor failed to contact its project manager, which undermined its evidence point. Now, the court thought that, and it seems to be that there was difficulty contacting a previous director, and this wasn't due to COVID-19. So, there seemed to be, obviously, there may have been a split between the company and one of its directors, which may not have gone down well. So they're saying that alone cannot be a reason so as to grant an injunction either. So those reasons the TCC refused the injunction, and what they said was that the TCC confirmed that it would only grant an injunction to ongoing adjudications very rarely and in very clear-cut cases, and satisfying the criteria for an injunction under the well-established principles in American Cyanamid versus Ethicon. Now, they're the three principles that you have to satisfy in order to grant an injunction. The threshold is very high for an injunction. It is an equitable form of relief, and it is very, it's very much open to the court's discretion. And they're saying that unless you have really clear-cut reasons why an injunction should be granted, they simply are not going to grant one. So the conclusion here is that COVID-19 delays are unlikely to amount to a breach of natural justice at enforcement, but this will be dependent on the facts. Now, what you're saying was that, you can see the importance of the facts in the Milchrist case, because they're saying that there was other issues, there's other reasons really why Milchrist weren't, active in putting forward, in taking part in the adjudication. So what we're saying, but that would be dependent on the facts. I mean, if there are some very specific set of facts, that may be taken into consideration. But if it is along the lines of what the TCC dealt with in Milchrist, then what you're saying is that you're granting an injunction on that basis is unlikely to be sufficient. In order to succeed, there must be clear causation. Without any other events breaking the chain of causation between the events unfolding and the ability to plead a party's case. So there you have, they're saying that, if there has to be clear causation. So, and if there are very specific points, again, they will take those into consideration. And finally, they're saying that the parties must mitigate the effects of any causation, and parties should not rely on COVID-19 as a means to delay adjudication in order to gather more evidence. And that was one of the thoughts that the TCC had in their minds, was why Milchrist weren't taking part, was because they were using it as a delay tactic, especially because they were the responding party. So Waters may have started the adjudication, and it could have been the case that Milchrist just were wholly unprepared to take part. Obviously, people had left the business, so it was obviously going to find it more difficult to, present its case and provide the evidence that it felt it needed in order to successfully defend. So yeah, it's just I guess a word of warning, I guess, to parties who are probably maybe dealing with any live adjudication proceedings, that there's going to need to be very clear reasons as to why the adjudication shouldn't proceed in the current environment. It's clear that there may be extensions required, but that's fine. Extensions are commonly granted in adjudication proceedings, and the court is saying that they can just as equally deal with if the effects of COVID-19. So yeah, look, that's the lesson to take away from Milchrist versus Waters. And but I mean, if you feel that you have very specific set of facts, and don't say, they're not closing the door completely. What you're saying is that you're coming in for an injunction under those principles in American Cyanamid versus Ethicon. The threshold is it's very high. So you need to have good evidence, and you also need to have showed that you've tried to mitigate the circumstances why you feel the adjudication shouldn't continue. Just sitting back and saying that, well, I think an injunction should be granted here, without having even attempted to engage in the process, the court will take a dim view on that. So yeah, deal with your adjudications as normal. Extensions will be granted. And it's much in the it's the messages the courts have sent this from day one, is that they're trying to keep it business as usual as much as possible, and the Milchrist and Waters case does just that on the grounds of adjudication. Okay, so look, we're gonna wrap it up there. So just to conclude, we've obviously looked at the position on the true value adjudications. Following Grove versus S&T, it's just a reminder on that one. Obviously, the sums stated as due in the first adjudication has to be paid, before you commence the second one. Just bear that in mind. That is the key point to take away from that one. Then insolvency, we looked at, the case of Bresco versus Lonsdale, very recent decision, only last Wednesday. And what they're saying is that adjudication is open to liquidators and indeed administrators, where they seek to recover sums, just in the same way as all other court proceedings are available as well. So, it's likely that liquidators will start to take up the adjudication process a lot more going forward. So, we wait and see. I mean, it's too early to say what the effect of that will be, but that's what the anticipated outcome is there. And finally, we've dealt with COVID-19 and adjudication. Where a party is seeking an injunction, or it simply doesn't want to engage for whatever reason. You need to have very good reason for the court to grant an injunction. They're going to give extensions, and again, they're trying to keep it business as usual, as much as possible. And yeah, so the message is deal with your adjudications as you normally would. And if you do that, then you stand a chance. But don't just expect that that the adjudications will be granted very easily, because that is absolutely not the case. So I'm going to wrap up there. And yeah, look, I want to thank you all for listening in this evening. And I know it's a lovely evening out there. And yeah, we can deal with some questions now. And Julie,
yeah, I've got some questions for you, Conor, don't worry.
Okay, great.
Question that came in, I think this is when you were talking about insolvency.
Yeah.
Someone's asked, so that the ruling you were talking about, so this supports that a party can adjudicate at any time.
Yeah, absolutely. Yeah.
Right.
But the key point is that, sorry?
Like, so you were saying?
Yeah, absolutely. That's what the legislation says. Parties can adjudicate at any time. And the Supreme Court are backing that position, but they're saying that even when a party is insolvent and the liquidators are involved, and it's the liquidators that want to bring the claim, they're saying that absolutely adjudication is a route that is open to liquidators if they want to recover these sums. So yeah, that's the message. Again, it's saying that it's in very exceptional circumstances that adjudication will not be a viable method of dispute resolution procedure in order to solve any disputes. So that's the key message, and it's just extended now to insolvency as well. And yeah, that's the position as it is now, and will be into the future.
Okay. Someone else is saying here, given the quick timescales, the appointment of an adjudicator must be secured within 7 days from service of notice to adjudication. How do you ensure there is no conflict of interests with the appointment of an adjudicator?
I mean, this goes back. Well, I mean, that's something that that we trust the nominating bodies to, because when we file our request to appoint an adjudicator, conflict checks will be undertaken at that point by the respective nominating body. So at that point, then is that obviously any adjudicator that has a conflict with any of the parties who have been named in the nomination form will have to declare their the conflict there, because I mean obviously they shouldn't be taking part if they are conflicted, or they are privy to information which may prejudice one of the parties. And I mean, if that comes out, like it won't be a good, like the adjudicator will not look good as a result. So yeah, it never really happens. I mean, they're very careful to make sure that there are no conflicts early doors, like solicitors are. I mean, it's a key requirement to resolving any dispute.
Yeah.
Yeah.
Okay. And someone's asking, can you provide an example whereby you can adjudicate, but that doesn't mean you should adjudicate when considering the value of a claim, potential recovery, and adjudicators?
Yeah, I mean, this comes down. I mean, like this comes down to weighing up the the strengths and weaknesses of your respective claim. Um, at the outset, before pushing the button to issue a notice to refer. I mean, it's part of the standard, analysis. I mean, especially contractors can do this, but solicitors, and we spend a lot of time advising parties on what we think the strengths and weaknesses are, and also giving an indication then as to the costs involved, because because costs obviously are an important factor. And if your dispute is a dispute, say for for £10,000, we're going to say that you could potentially have an adjudicator's fees for those amounts. So we're going to say it's probably not worth the risk of issuing adjudication proceedings, and it's getting around the table to try and agree a negotiation, or you could in fact mediate it if you so wished as well. But it just depends on, I mean, it comes back to the commerciality of the case and the sums involved, and like the company status, I suppose the importance of cash. I mean, one of the great things about it, like the adjudication, is obviously the speed, because you get a decision in most instances within 28 days, and obviously that can make a big difference to a company that is struggling for cash flow. And that might be one reason you might think that you think it's going to be quicker to get the money through adjudication than it is to to try and sit down with the other party, especially where they're being evasive and trying to avoid payment, which does happen pretty frequently as well. So you got to weigh it up on the merits. The sums come into account, but timing is obviously very important, and they are the two key requirements that adjudication provides. And yeah, definitely what needs to be weighed up at an early stage before deciding on whatever route you take to try and resolve your dispute and recover as much as possible, which is the name of the game as well. So yeah, that's the advice that I can offer to you there.
Okay, well, thank you for that. That's all the questions answered, Conor. And thank you to everyone for joining us tonight.
Sorry, Julie.
Yeah.
Julie, I had one question that was that had been asked before the seminar.
Yeah.
And the question was, it came in there just before the webinar, and
how is adjudication relevant in a contract that has no adjudication clause with both parties agreeing to it?
Correct. Yeah.
My apologies. We nearly missed that one.
No problem. So again, it goes back to the point that the legislation says, and it's section 108 of the the Construction Act, says that the parties to a construction contract have the right to refer a dispute at any time. So that's embodied in the statute, and the only way, the best way that but there is an exception to that, and the exception to that is the residential occupier exception at section 106 of the Construction Act as well. And that's so if you have a residential occupier involved in the contract, then you can contract out of statutory and contractual adjudication if that's what the parties wish to do. But you can't override statute in the contract to say that you don't want adjudication to apply. And there is yeah, I mean, like, just a bit of background, contractual adjudication. I mean, adjudication, became very popular, obviously, as a result of the Construction Act, but contractual adjudication had been in place before that. The problem was that most parties were contracting out of it. So therefore, you didn't have a buildup of the adjudication cases, which we've seen an influx since, since 1998, when it became enshrined in the statute. So, the parties can say, they can say it in the contract, but ultimately, if it's a construction contract and it satisfies the requirements in section 108, obviously consider the dispute has crystallized, and as I said, it is a construction contract, then there's the option, you can't exclude it. I mean, you can agree it in principle between the parties, but unfortunately, if the relationship sours later on in the project, you know, the section 108 will kick in, and the right to refer at any time is to do just that. So so be careful when you're seeking to agree such clauses.
Okay.
Yeah.
Thank you for that, and thank you for remembering, Connor. It was a test you passed. Well done. Good job. Right, we will be obviously posting the video of this in case anyone wants to refer to it up. If you've got any specific questions you'd like to communicate with Connor, you can see Connor's email is there on the screen, and it's in the slides which are available for download on the website. Thank you all for coming tonight. It is, as Connor pointed out, a beautiful evening, so we do appreciate the fact you're taking time out to join us and listen to Connor. Connor, thank you for your time as always and your expertise.
Thank you, Julie. Thank you, everyone.
Yeah, we will see you all again soon. And in the meantime, stay safe and enjoy the sunshine, everyone.
Very good. Thanks, everyone.